After the petition and summons are properly served on the tenant, the attorney will attend the hearing and advocate on behalf of the property manager to seek eviction of the tenant. The property manager may need to attend the hearing to serve as a witness. If the tenant appears at the hearing, then some counties will first require the parties to attempt to mediate in another room. That could be an opportunity for the parties to try and work out a move-out agreement, or perhaps an agreed judgment to present to the judge. But if no agreement is reached, then the parties will go back in front of the judge and hold a short hearing. The property manager will want to work with their attorney to evaluate their case strategy, and how much testimony will likely be needed will depend on the circumstances at issue in each particular case. The judge will give each party an opportunity to be heard. And since the case is in small claims court, the judge may actually have questions for each of the parties before making his or her decision. If the judge rules in favor of the property manager, then the judge will enter a written judgment to that effect which awards possession of the premises, and possibly back rent and attorney fees depending on the circumstances. After judgment is rendered, the property manager's attorney will most likely ask for a writ of execution to be issued, which is where the judge orders the county sheriff to remove the tenant from the property. The writ is provided to the sheriff's office, and the sheriff will usually go out to the property and serve the notice. This is usually done by the sheriff placing the notice on the door and advising that the sheriff will return in 48 hours to restore possession of the premises to the property manager. If the tenant still refuses to leave, then this will involve the sheriff physically removing the tenant from the property. At that point, the eviction is completed, and the property is legally returned to the property manager.